What new powers has the European Union gained after the Lisbon Treaty on the international stage?
Right. Well, it's a trickier question than one imagines, because it's not quite clear what can be understood by gained and competences. Okay, to get one thing out of the way, it's still an institution of conferred powers. It was before, it still is, which means if there's an international situation, the Union first asks, are we competent, before asking, how can we act effectively? All right. What that also means is that there's two basic questions you need to ask yourself, or the EU needs to ask itself. Do we have competence? Point one. Point two, what is the nature of that competence? Is it a shared competence? Is it an exclusive competence? Etc., etc. And gaining competences can mean all of that. It can mean they've added legal bases. For example, Article 8, European Neighbourhood Policy, or Article 214, Humanitarian Aid. That's one thing. But it can also mean we have our competences, which we already had before Lisbon. We're interpreting it more broadly. We're giving the Union more scope of exclusive powers. It can mean all of those things. An exclusive power, for example, that has become larger in scope is the common commercial policy, the most powerful EU external action, I would say, or part of EU external action. That has gained quite a lot of scope to align it better with what the WTO does. Now, another issue is whether the European Union can act in places, and that has also been clarified by Lisbon, in places where it has no explicit competence, so the so-called implied competences. And that was developed by the Court of Justice in a very long and complicated case law, now codified in Article 216. And there you have such a broad drafting that it may give rise to more external competences possibly than the drafters had anticipated. I think especially of one phrase which says the Union has the powers necessary to enable it to attain certain goals, objectives of the treaty. What does that mean, objectives of the treaty? Does that mean objectives of a specific policy or the general objectives in Article 21? Depending on the answer to that question, the Union can have gained an enormous amount of powers if the answer is any objective they can find in the treaty. So it all depends on how the Court of Justice will deal with it.
But the member states and the EU often act in parallel on the international stage. How can you avoid of them contradicting each other?
Yeah, and the answer is not always, clearly, because there are instances, recent instances, even after Lisbon, where member states and the Union clearly and publicly contradict each other, or indeed the institutions of the Union contradict each other publicly. Okay, that's a different story. How can you try and avoid that? Well, you can try, of course, going by the route of principles in the treaty and saying we shall write down in the treaty certain mechanisms, certain principles, which hopefully will try to avoid us publicly falling out, shall we say. And the main principle that helps in that regard is the principle of sincere cooperation. Sincere cooperation in Article 4, third paragraph, which is not just a principle, to be clear, it's not just a principle in EU external action, it is one of these general constitutional principles of the European Union, and it just means, actually very simply, let's all act to make this work. What that means is a positive and a negative duty. Do things to make this work, both externally and just on the internal level, all of us, institutions, member states, the entire structure, but also do not do things which are clearly intended not to make it work. Okay? Now that is the principle. That is the principle which counts for EU law in general, for EU external action in general. There's also a very specific incarnation of that for the common foreign and security policy. Why? Well, because the common foreign and security policy is, as a structure, so weak, to be perfectly honest. It provides a potential for the member states to act together, but there's almost no obligation there. So the drafters of the treaty clearly found it necessary to spell out this need for cooperation, for coordination, even more clearly, which basically means talk to each other as well, inform each other. And that is also clear from the case law of the Court of Justice, which has played a crucial role in trying to give this sincere cooperation some teeth.
You mentioned the case law of the court. What's the role of the Court of Justice in general in EU external relations? Can it help to create more coherent external action?
Well, it can certainly try. So the court has played a very crucial role, as you say, in general in EU external action by giving the European Union the possibility of interpreting the treaty in such a way and the limited explicit competence in the treaty in such a way that it did have a viable external competence. That's the entire implied competences case law. We won't go into that in detail now. But it can also, and it has been in the last couple of years, reinforcing this duty of cooperation, which I just mentioned, by telling the member states, these things, these certain steps you do in your external policy, you can't actually do when you take into account that you're also operating within the framework of the European Union's external action. You mustn't impede the European Union from having an external policy. And I'll give one example, a fairly recent example, which was Sweden trying to add a certain hazardous chemical to a list of hazardous chemicals in the Stockholm Convention. Even though, so what had happened is that they had talked about that in the Council, and everyone had agreed, let's not add this yet, because this will bring all sorts of problems, for example, with development cooperation. Let's just agree not to do anything for the moment. And Sweden had said, well, we're displeased with that, but okay, we agree, but if we take too long to make a final decision, we will submit it anyway. Now, how long did Sweden wait? 1 week exactly, more or less. And then it proposed this addition. Now, it was acting within its own competence, let's be clear. It was acting within its own competence, but it was acting against something that was agreed as a strategy. And the Commission took Sweden to the court, and the court said, Sweden, you can't do this. This is disloyal, and you are basically running the risk that the European Union will be negatively affected by what you've just said. Now, all this applies, what I've just said, only within the traditional community competences, which are now also found, or only found in the Treaty on the Functioning of the European Union, not in the CFSP. Why not? Because the court has no jurisdiction in the CFSP, and it still, after Lisbon, only had very, very limited jurisdiction in the Common Foreign and Security Policy.
So the CFSP remains a special case. What else makes the CFSP special, and why is this still the case after Lisbon?
Well, where to start even? The CFSP, I think, is as special as it was before Lisbon, possibly even more special. Everything is different about it. It has no specifically attributed competences. There's only this very large competence of all areas of foreign and security policy. There's not this specificity which you find in the first pillar. There's a very limited role for the European Parliament. There's the reversal of the role of qualified majority voting in the Council. Normally it's the rule. You vote by qualified majority in the Council if there's no other specific rule. But in the CFSP, it's exactly the opposite. There's unanimity, and only in very specific cases QMV. So all this, it's still a very, very specific thing. And to me, at least, this implies that the pillar structure has been largely destroyed, but not with regard to the CFSP. For the CFSP, the pillar is still standing, I would say. And why is that? Well, because the CFSP is as close as you get to the core of sovereignty that is left with the member states. A united high politics foreign policy, war and peace, all these things, is the sort of final thing that states are willing to surrender, I think. So that's point one. They want to keep entirely in control, remain entirely in control, as they are in the current framework of the CFSP. That's one reason. Secondly, they have all the assets. The member states are the ones to put it brutally, with the armies, and they have the big diplomatic machineries. I mean, the European Union has a diplomatic machinery, but far less experienced and far less powerful than, for example, the Foreign and Commonwealth Office of the United Kingdom. And so the Union needs to rely entirely on member states' assets, and again, they want to remain in control. And this is why I think the CFSP is still different and will remain different for the foreseeable future, I think.
And what about the European Parliament? I mean, what role does it assume in EU external action?
Well, I would say it plays quite a large role, also in comparison to national parliaments. It really does, I would say. And if there's one constant in EU integration, is that with every treaty change, with every new treaty amendment, the European Parliament gains power. Let's not forget it started as an assembly, as a combination of national parliamentarians getting together occasionally to talk about European matters. Now it's a really, really powerful institution, especially in foreign affairs and external action. And I'll give a concrete example. What happened at Lisbon is that the ordinary legislative procedure is now, well, as the word says itself, the ordinary legislative procedure applies for the majority of internal matters. Now, externally, what this implies is that the European Parliament, by virtue of Article 218, needs to give its consent to every international agreement which covers matters that internally are covered by this ordinary legislative procedure or by a special legislative procedure which requires consent. Now, the two of those combined make for a small revolution, actually, and quite a significant extension of the European Parliament's powers in external action. And a concrete example of that is trade. Before Lisbon, it's difficult to imagine now, but the Parliament had almost no role in the common commercial policy, the most powerful and successful external policy of the Union. I would argue it had almost no role. After Lisbon, it's internally involved via the ordinary legislative procedure, externally by giving consent. Now, all this works slightly differently, as always, within the common foreign and security policy. Within the common foreign and security policy, the Parliament is kept as far away as possible from any concrete involvement in taking decisions and only gets to give its general idea about the general direction of the CFSP. Now, that is, I think, not satisfactory, especially because sanctions are also taken within the CFSP. But is it worse than in other constitutional systems? That, I think, is another question entirely.